So let's get started. We have 3 lawyers leading today's webinar. First off, I'd like to introduce you to Alex Levy of Hauser Henry and Syron. Alex has recently been made partner with the firm and has been with Hauser Henry and Syron for over 7 years. Alex focuses on general corporate and commercial law with a special interest in mergers, acquisitions, corporate governance, and succession planning. Alex regularly advises both purchasers and vendors of multi-million-dollar mid-market private companies across various industries. He also advises companies on employment matters and works with individuals on estate planning. Welcome, Alex. Next, I'd like to introduce Justin Anisman, an associate with Brauti Thorning. Justin's civil litigation practice at BT Legal encompasses complex litigation files with an emphasis on commercial and contractual disputes and employment law matters for both employees and employers. He has extensive experience in the day-to-day handling of a large volume litigation practice and has represented clients before all levels of Ontario court, including the Supreme Court of Justice, the Provincial Court of Justice, and the Ontario Court of Appeal, as well as the Supreme Court of Canada. Welcome, Justin.
Thanks.
And last, certainly not least, I'd like to introduce William McLennan, an associate with Brauti and Thorning as well. William's practices in all areas of civil litigation with an emphasis on employment law and general commercial litigation. Before joining the firm in March 2020, Will articled and worked as an associate at Ontario's largest labor and employment law boutique. He has represented clients in various administrative proceedings, as well as before the Ontario Superior Court of Justice, including the Commercial List and the Divisional Court and the Alberta Court of the Queen's Bench. Welcome, Alex, Justin, and Will. And now I'd like to turn the floor over to Alex, who will kick off the webinar this morning. Alex,
Thank you very much, Lisa, for that introduction. And good morning, and thank you everyone for joining us today. We are very excited about this presentation because it covers a topic that on its surface may seem very simple, but when you dig a little bit deeper, there are really many factors at play that need to be carefully considered. And in the sale of a business, we see the majority of business owners are focusing on revenues, profitability, key contracts, and then as far as employees are concerned, the focus tends to be on ensuring that key employees will continue on with the purchaser organization. However, in the sale of a business, employee liabilities can be a major area of concern and a significant expense. But please bear in mind, when we discuss employee liabilities throughout this presentation, we are primarily talking about the potential cost of termination for certain employees that will either not be retained by the purchaser or will not be offered continued employment. So our goal today is really to give you an understanding of the framework and how to view employee liabilities in the context of an asset sale, and then run through the various considerations and options that both the vendor and purchaser should be considering. So to properly examine this issue, I will start at the basics and first explain the difference between a share sale and an asset sale because they have two very different impacts. In a share sale, an owner is literally selling the shares of the underlying operating company. Accordingly, in a share sale, as far as employees are concerned, their employment is not affected. The company an employee was working for prior to the sale of the shares of that company is going to be the same company as afterwards. There's no risk that the employment relationship is terminated or may be deemed terminated by virtue of the sale itself, unless the parties go out of the way to make that a condition of the terms of the deal. So in contrast, in an asset sale, the actual identity of the employer is going to change for the employees that choose to accept an offer of employment with the purchaser. And there's an old doctrine in the common law, which is judge-made law, that an employee's employment contract cannot be assigned without an employee's consent. So in other words, employees are not going to be treated like just another business asset. It's actually a humane concept, one I agree with, but it has far-reaching consequences, which we will explore today. And so in an asset sale, a purchaser and vendor, we feel strongly, should not only be considering the sale price and other key business terms, but also what is going to happen to the employees. The question of whether a company should enter into an asset sale or a share sale, I just want to mention, is in of itself a far more complex question, of which employees are just one concern. But it is something that is important, and we have seen it get in the way or hold up the closings of several deals. And next slide there, please, Lisa. Another important element to understand when analyzing employment-related liabilities in an asset sale are the obligations that arise under both legislation and the common law. In particular, in regards to legislation, the particular one we're referring to is the Employment Standards Act, which, forgive me if I refer to it as the ESA going forward to keep it simple. And the ESA sets out, among other things, a minimum entitlements that employees are entitled to receive both during the course of their employment as well as upon termination. So we have the ESA in one hand, and then we also have the common law, which we refer to as judge-made law. And Canada is a common law jurisdiction, just like the USA and Britain and most of all of the Commonwealth countries. And our courts interpret legislation through court decisions, which in turn leads to the creation of additional rights and obligations that employers are required to follow. Most business owners will be somewhat
Alex, you are on mute.
Oh gosh, how long has that been going on for, Lisa?
Just a couple of seconds.
Oh, okay, my apologies. So I was just talking how the ESA sets out the minimum entitlements that employees are entitled to receive for a number of factors, including guiding the employment relationship and upon termination, and then just trying to state the difference that the common law, which is judge-made law, that Canada is a common law jurisdiction, just like the USA and Britain, in that what happens in common law jurisdictions is that our courts interpret legislation, and have decisions, which in turn lead to the creation of additional rights and obligations that are binding on us and sort of guide how we have to act. Accordingly, I'm going to address the ESA first. And most business owners, I'm not sure if everyone heard this part, but they're going to be somewhat familiar with the provisions in the ESA regarding minimum termination and severance entitlements. And I'll just recap it briefly. So at a minimum, the ESA prescribes that an employee is entitled to receive upon termination approximately 1 week's wages per year of service, up to a maximum of 8 weeks. In addition, if a company has a payroll of over 2.5 million and has been employed by an employer for over 5 years, that employer will be entitled to receive, in most cases, a 1 week's wages per year of service, up to a maximum of 26 weeks. Now, please bear in mind, these are the minimum amounts. The minimum amount of termination pay set out in the ESA will only be available for the benefit of the employer if it's clearly set out in an enforceable employment agreement. However, if an employee's termination entitlements are not limited to the ESA amounts in an employment agreement, which is probably one of the most contested areas in all of employment law, then an employee would be entitled to reasonable notice under the common law if their employment is terminated, where the amounts are far greater. So to recap at this point, let's assume in a hypothetical, we have a vendor that wants to sell the assets of its business to a purchaser, and we have very broadly and quickly walked through what an employee might be entitled to receive upon termination. So the next question we're going to consider in our analysis here is, what exactly happens to employees when the deal closes? Is the employment terminated? Is there a way to mitigate the longstanding service of certain employees, which my colleagues will touch on? And can purchasers specifically refuse to acknowledge prior service? And how do we contractually deal with this? These are the issues we really want to dig a little deeper on. But as we move forward, please just bear in mind there's an ESA component to the liabilities we're discussing, and then there's common law liabilities to consider. So first, I'll talk about that ESA component. Yeah, just next slide, please, Lisa. And the key point I want to touch on in the ESA is the continuance of employment provision. So as noted in the previous slide's content, the ESA cannot be modified or restricted. It applies full stop for one of the primary purposes of the legislation, which is protecting employees' rights. So Section 9 of the ESA is copied on the slide in front of you. And it states clearly that if a seller sells a business or a part of a business to a purchaser, and the purchaser employs an employee of the vendor, then for the purposes of the ESA and your rights under the ESA, employment is deemed to be continuous. Now, there's two important things to know. First, what constitutes the sale of a business or a part of a business is a bit beyond the scope of this presentation. Just keep in mind, though, that this would be important to determine in situations if you're only selling a part of a business, say a specific division or segment, then this becomes a very real question if this section will apply to you. And second, I didn't post all of Section 9, so there is an exception to this rule, and that is if the purchaser hires an employee of the vendor 13 weeks after the employee's employment with the vendor is terminated. So quite a cooling down period. If there's a significant enough gap, then Section 9 will not apply and employment will not be continuous. But this, in my experience, happens very rarely. Usually the transaction closes and employees are transitioning at the same time. So on its surface, the Section 9.1 seems fairly straightforward, and it kind of is, but it's worth discussing the impact of it and how this interacts with the common law. A purchaser often wants to explore options on how to circumvent Section 9. Well, maybe not circumvent, but how to deal with it for obvious reasons. And that's because in an ideal world, a purchaser would probably prefer to start its relationship with each employee with a clean slate, ideally recognizing service lengths only when the date of employment begins with the purchaser. And so what this leads to is that one of the most common suggestions or solutions we see purchasers ask for is asking for the vendor to terminate the employment of employees immediately prior to closing. And the timing of the termination matters, but usually we're approached and they want the vendor to, right before closing, terminate the employees we don't want to employ, or terminate everybody. So try to get rid of the length of service. But this can have unintended consequences and may not achieve the objective. And that's because if an employment is terminated, you can't contract out of the ESA, so they'll automatically be entitled to receive their minimum termination payments. So take a 20-year employee, and the vendor is now obligated to pay that employee a minimum of 8 weeks' wages and continue their benefits. But also keep in mind that the purchaser can't contract out of Section 9 of the ESA. So you might be in this bit of a limbo period, not limbo, but where the employee has been paid out by the vendor and the purchaser thinking they might have a clean slate under the ESA, but they really might not. And what you might have done is give the employees a bit of a windfall. So the key to remember here, though, is that Section 9.1 is only talking about ESA rights and entitlements. It's a common law concept, but it is in the purchaser's power to enter into new contracts with employees. And so while the purchaser can't contract out of ESA minimums, it can, to the extent permissible by law, refuse to recognize all the prior service of an employee apart from any ESA obligations, but my colleagues will get into that. So it's a fine but important distinction. So I will lastly touch on in the next slide a bit about the common law. And I just want to reiterate the concept that an employment contract cannot be assigned by one employer to another. But case law has evolved substantially in the field of employment law and asset sales, and it has a principle that confirms that where a purchaser is acquiring a business as a going concern, there will be an implied term of continued service. So the first question might be, what is a going concern? This has been described and analyzed in many decisions. In one Ontario Court of Appeal case has described it as the transfer of a functional economic vehicle, the activities of which could not be carried on without interruption. So where a business is sold as a going concern, which again is a bit of a test that's beyond the scope of this presentation, and the purchaser makes an offer to an employee and the employee accepts that offer of employment, what the common law will say is it will dictate that the employee's past service with the vendor will be recognized absent an express intention to the contrary, preferably in a written agreement. So unlike the ESA, which holds that employment remains continuous and you cannot contract out of it, the common law gives the purchaser a chance to not recognize prior service for common law purposes. Now, if I go any further, I really will be stepping on the toes of Will and Justin, so I will stop now and turn it over to Will. Thank you.
Thanks, Alex. I think there's going to be toe stepping a little bit. Like you said, it's a very complicated area of law. I'm going to go over with Justin some of the fallout from this, some of the scenarios that are most common from an asset sale when thinking about how to deal with the employees. And as Alex said, we're scratching the surface and it gets very complicated. So there will be many little nuances here and there to think about in each one of these scenarios, and they overlap slightly, but these are the basic ones that are helpful to think about when approaching these problems. So the first scenario is when an employee of the vendor is not offered employment by the purchaser. That's typical what Alex terminated by X date, usually sometime around closing, and the vendor is responsible for that liability. So the ESA, the common law, all of that. The second scenario is where the employee of the vendor is offered employment by the purchaser under the same or substantially the same terms that are in place with the vendor at the time. And then the third scenario is just another variation of that theme, which is the vendor's employee is offered employment by the purchaser under substantially different terms. And what we mean by substantially different terms, it varies, but effectively it's a fundamental change to one of the underlying conditions of employment, something that Justin's going to get into a little bit more. I'm going to go over the first two scenarios, and then Justin will discuss the third in a bit more detail. And then I think after that, we're moving into questions. So Lisa, can you go to the next slide, please? This is the general scenario. When a business is sold, it's deemed to be a termination. So the vendor is liable, generally speaking, for the severance pay, the termination pay of that employee, because their employment with that employee is ending. When looking at that, there are two ways to deal with those obligations. One is to provide notice of termination. The other is to provide pay in lieu of notice. So what Alex was talking about earlier was under the ESA, there are certain minimum requirements. That's what we're talking about, those minimum number of weeks that you might owe someone. At the common law, those are a little bit different. It's not based strictly on whether you've been there for between 1 and 2 years, between 3 and 4, what the payroll is at the time of termination, how many employees are being terminated. It's really based on what we call the Bardol factors. And I'm jumping down a little bit, but I just want to go over those. Those are things like the character of the position, the years of service, the age, and the availability of comparable employment. People familiar with employment law will be familiar with those terms and will be familiar with the general rule of thumb, which is that you get 1 month per year of service. That's not entirely accurate, but it is something that can be used in pinch to think about what you might owe someone. That's the common law requirement, though. So that's what we're giving in terms of notice or pay in lieu. Are we giving 8 months notice, 4 months pay in lieu for a total of 12? Are we giving some combination of that more towards the notice or the pay in lieu? There's benefits and disadvantages to both of those. Typically, the vendor, if possible, is going to want to advance as much notice as possible. This is because you're not paying for discounting that. You're getting the work from the employee, and it's not as large of a lump sum. This is especially the case if the employer doesn't intend to offer continued employment, because if you can give enough notice at the outset, then when the asset sale takes place, when the termination takes place, you'll have discharged your notice obligations as the vendor, and you'll not have to pay anything out as a lump sum. The problem with working notice, as most people can think of, is that this increases the risk that the transaction might go awry or that the business might lose value in the interim. So something to think about from a practical level, for example, Alex mentioned key employees. If they know that none of their friends are going to be working at the new company and they have 12 months to think about that, not only will you have lower morale at the company potentially and less output, you may also have key employees and other employees seeking alternative employment. And in some asset purchases, whether or not a key employee is moving over, whether or not the person with the knowledge how to run the going concern is moving over, may be a serious sticking point for the asset sale. So that's something to think about. The alternative, of course, is that payment in lieu of notice eliminates many of those risks, but it has significant increased costs. So just to think, if you have 10 employees at a company, 9 of whom aren't being offered employment, and they've all been there for 10 years, you may be looking at many months of notice, and that's an outlay at the beginning that you may have to pay. That's something to think about in terms of the cost of the asset transaction. Potentially, that's something the vendor will want to negotiate into it. Maybe the purchaser will want to pay something towards it to ensure that they're terminated in time. These are all questions that might arise when employment's not being offered by the purchaser. To return to some of those key considerations, then, one of the things that you're going to want to do no matter what, when you're looking at all of your employees, even if there's no employment being offered, because the purchaser will want to know the potential liabilities, is you're going to look at whether there's enforceable employment contracts, because Alex was saying you can contract out of these common law entitlements. And if there's an enforceable contract, which is increasingly rare, but it's worth looking, you may find that you don't actually have to pay the larger common law entitlement under those Bardolph factors. You'll want to think about the Bardolph factors that I mentioned before. You want to think about the human rights considerations. So you will want to interrogate why a purchaser isn't offering employment to certain employees. If, for example, there's someone on a parental leave, if they are only hiring men, which who knows, maybe that's going to happen. These are things that could leave either the vendor or the purchaser as well with human rights violations and breaches to the Human Rights Code. And that can increasingly become more and more costly. And then we've already discussed the morale of the remaining employees. Again, this is a factual analysis and a practical analysis for every transaction, but these are the things you'll want to be alive to if the purchaser signals an intention not to hire some or all of the vendor's employees. Next slide, Lisa. The next scenario is where the purchaser offers employment to the employees or intends to offer employment to the employees on substantially the same terms. Justin is going to talk about new terms a little bit. In some cases, the purchaser will likely or may want the terms that the vendor already has employed the employees on. That's unlikely, given that employment law moves very quickly, and there may be many changes to the law since the contract has been entered into. Further, a purchaser may want to change the location of work, limit entitlement to notice on termination. They might want to impose more useful restrictive covenants, although Ontario just said that we may not have non-compete covenants in our employment contract soon. Which is another thing you might want to change. If that is in there, query how that might affect the enforceability of the rest of the contract. This poses considerations for the vendor, but it also engages how to reduce liability in making those changes. That's something that Justin's going to touch on. A common covenant that you would see the purchaser giving potentially, or the vendor demanding, to flip it from what Alex was saying, is that they will adopt contracts for their employees that are substantially similar or as favorable as the contracts currently in existence with the vendor. For purchasers, it's important to keep in mind, though, that they're not legally required to make an offer to employees. As we discussed earlier, the vendors are the ones who are liable for the employee's termination and severance pay. There's no reason for the purchaser to necessarily take that obligation on, unless, of course, it's a key employee who they want to continue along with them. Good news for purchasers is that an offer from them is usually in and of itself considered fresh consideration to make a new contract enforceable. The Court of Appeal has said that only a few years ago, and it's not been challenged by any ruling that we can think of. And it was brought to the Supreme Court and they said, no, it's fine. They dismissed the appeal. They didn't even hear it. So that's good news for purchasers. But as Alex was saying, even if you offer those similar terms or substantially the similar terms, there's also the common law principle that may imply that the purchaser is taking on the past service of the employee at common law. They're going to take on the past service under the ESA because that's statutory and can't be contracted out of, but it's a consideration for the purchaser to think about if being asked by the vendor to continue on substantially the same terms, because you may be on the hook for 20 years of service that you didn't have before. All the more reason to do a proper analysis of those Bardolph factors and human rights considerations and so on that we discussed earlier. This could, however, increase the chance that a key employee will accept employment. It's much easier to take on a job with a new employer if nothing's going to change for you and it's going to be status quo. And given that there's practical considerations around an asset sale, that's something that the purchaser will want to think about. For vendors, this is something that they really will want to push because it engages what's known as mitigation. So if you as the vendor are liable for potentially a year of notice for an employee, say, and you only have 8 months until the end of the transaction, and you think, in any event, I'll give them 8 months working notice, I think it'll be fine, you're still potentially on the hook for 4 months of notice there. But if they're offered employment by the purchaser and they refuse that employment, although the employment was on substantially the same terms, they could be accused of failing to mitigate those last 4 months of their notice period, which would negate the liability for, or could negate the liability for the vendor. Although there's benefits and demerits to this approach, and although fresh consideration isn't necessarily required at law, we tend to advise that offering fresh consideration is a good idea for a number of reasons that I've covered, including the practical benefits, but it increases the chances of acceptance for both parties. So the vendor wants the key employee or any employee to offer or to accept that employment because it is a mitigation. The purchaser may want those employees to come over because they're part of the going concern or they're the know-how that will ensure the going concern can continue. It reduces the possibility of litigation by employees, even if that litigation would have been misguided otherwise. It's one more tool in your arsenal to say you were given a $5,000 signing bonus. This is an entirely enforceable agreement. And a lot of employment lawyers will send out a demand letter and hope that they're going to get a little bit more money. So this is a good tool to have in your arsenal. And then it's something that we can discuss a little bit more. It's getting into the weeds a little. Alex was talking about the non-assignability of an employment contract. That's because the employee has to agree to the assignment. And there's certain things that we can do to ensure that they do agree to that assignment if perhaps we do want to assign the old contract because it looks fine and we want to avoid some of these implied terms. A signing bonus can act as consideration for that assignment, or sometimes what we call novation, which is where the employer, the purchaser, the vendor, and the employee will all agree that the employment and the contract obligations are transferring to the purchaser despite this common law exclusion of assignment. So while it's not strictly legally required, we often do recommend fresh consideration as a signing bonus, a salary increase, because it papers over a lot of these complicated issues and could save you a lot of heartache down the line if the sale goes awry. I'll now pass it off to Justin, who's going to talk about offering substantially different terms of employment and some of the issues that arise from that.
Thanks, Will, for teeing me up. And so in the context of an asset sale, almost all of the time, you're going to want to implement a new contract with the purchaser. The purchaser is going to want to implement a new contract with the employee. And that's more of a practical fact that most contracts, I would say 95% of the contracts that come across my desk are not good contracts. And when you have the lawyers engaged and you're dealing with the sale of a business and you're doing your due diligence, it is inevitable that you're going to see that there either are no contracts with a large number of employees, or that the contracts are very old and are no longer enforceable. Last year, I wrote an article about a new decision by the Court of Appeal called Waxdale, and in that decision, the Court of Appeal pretty much invalidated every employment contract in the province. Until that decision, and I won't go into technical details, but until that decision, very little attention was paid to the with cause termination provisions. And the Court of Appeal said that if they're not drafted properly, we throw out the whole termination provision. And so as a result, most contracts were invalidated. And so now you have all of these employees that are entitled to common law reasonable notice. And like Alex was saying, that's a substantial liability that the purchaser is taking on. And if it's not properly negotiated, then you could be losing a lot of the value that the purchaser is buying by this company, because you're taking on such a substantial liability, which is the future cost of termination of any employee. And so with that in mind, it almost always makes sense to use this purchase as an opportunity to implement up-to-date, modern, enforceable employment contracts. And there are two ways that you can go about doing that. And I would strongly urge everyone to do that, to do the first way, which is by agreement. You want to sit down with the employees or employee that you are bringing over to your business, and you want to get them to agree. And if you can get them to agree, then it's easy. There's very little risk, and it's simple, and you've brought them on board and allowed them to participate in the process. And so you're going to have happier employees. You're going to have less risk that they're going to leave on a short term. And you do that by preparing written contracts and offering fresh consideration. And what fresh consideration means is providing them with something that they don't already have. So you either give them a signing bonus, or you give them a raise, or you improve their benefits, and you do something that will ensures the contract is enforceable, and also that ensures that they will agree. And by doing that, you can now implement all of the things that probably were not in the vendor's contracts. You can ensure that there is the right to lay off an employee if work gets slow. You can include progressive discipline steps in the contract that are express. You can ensure that the termination provisions comply with the ESA minimum so that you don't have to pay common law notice. You can insert non-solicitation agreements for salesmen or key employees. All sorts of things that would be important for any purchaser. Okay, so that's the most common and probably the best way, and that any employment lawyer you hire would probably tell you this is the route you want to go down. But what happens if you start having problematic employees or groups of employees who just won't accept new terms of employment? And this really is something that applies regardless of whether you're in the midst of a sale, or if you just want to implement new contracts generally in a business. It really has universal application. So the Court of Appeal in a decision called Ronco laid out a test that permits employers to unilaterally change a contract. And the gist of it is that you can make a fundamental universal change to a contract so long as you do so with reasonable notice. And there's two ways that to bring this back to the context of an asset sale, you really need to do this one of two ways. Either you implement these new terms prior to the closing, so you have the vendor implement a new contract and you give sufficient reasonable notice to all employees. So if you have, so you give 2 years notice, let's say that, to be safe. You tell everyone that in 2 years, your contract's going to change and there's going to be all these new terms and you will be terminated if you don't on this date unless you accept these new terms. And then you set the closing to be on the date of these new terms be implemented, and all of the employees will then come over with these new terms to the purchaser. And the alternative is for the purchaser to implement these terms after the employees have accepted. But what needs to happen is you need to ensure that throughout the reasonable notice period that the employees are still employed on the same terms that they always were. And this is what happened in Ronco. So in Ronco, the employer, Western Inventories, went to Mr. Ronco and said, we want to change your employment contract. We're going to change it from Mr. Ronco had a term that said he would get 2 years notice of being terminated. And Western Inventory said, we're going to change that to 32 weeks. And Mr. Ronco said no. And then Western Inventory said, well, we're going to do it in 2 years. So now, too bad. And the Court of Appeal said, well, you weren't very clear in communicating that change to Mr. Ronco, so it's not applicable. And ultimately, when they changed his employment 2 years down the road, he was entitled to pay in lieu of reasonable notice. But in that decision, the Court of Appeal set out, here are the 4 steps that need to be followed if you want to implement unilateral contract changes. The first is you have to provide sufficient reasonable notice of the proposed changes to the employment contract equal to or greater than their entitlements, either at common law or pursuant to a valid employment contract. 2, you have to inform the employee that changes are mandatory and that his or her employment will not continue under the existing terms of employment at the end of the reasonable notice period. 3, you have to offer reemployment under the new terms under the terms of the new or revised employment contract. And you have to ensure, most importantly, that there's no fundamental changes are made in the interim period. And so it's that final step, ensuring there are no fundamental changes in the interim, that is important. So if you want to implement, now, again, from a practical perspective, if you have a group of employees that are being extremely difficult and won't agree to new contract terms despite your reasonable efforts to negotiate with them, you might not want to bring them over at all. But now, at least this is really more of the problem scenario where you need to implement changes and you need to bring over these employees. This is a tool in your utility belt that can be used. All right, so I guess we can go into the next slide. I think that really concludes the 3 scenarios. I just want to refer you to, first of all, the article that we've written about this topic is available on Hauser Henry's website, and there's a link to it in the slides, which Lisa is going to make available to all of you shortly. And I've also linked to my website, torontoemployment.law, which has a lot of good resources for you. I think we're going to move on to any questions, to a question phase. So if you guys have any questions, we'd be happy to address them now.
Anybody can ask a question if they unmute themselves, or if you're a little uncomfortable asking a question, you can type it in the chat box and I'm happy to read that out. I think we have a silent group here today, or shy ones.
Well, I'll jump in with a comment because I think you could almost distill this presentation down into the last scenario that Justin's really talking about here, and that's when you want to implement those new terms. So from a context of a deal point of view, you can see how it's really going to be a vendor essentially pushing that, hey, purchaser, you should really be hiring all our employees on substantially the same terms, because if you don't get that clause in the agreement, and that can slip by the wayside in due diligence and really lead to some funny scenarios at the end. You're really, it's a little too late. It has to be thought of early. You have to push for it early as a vendor, because as Will is describing quite clearly, you are the one left holding the bag. And it is really hard to back yourself out of that corner. Well, you know, money talks, and of course you'll back yourself out of that corner, but you'll be locked into a position where it's harder and harder to negotiate that for as many employees. So you really want to be upfront about that. And maybe if you're preparing your business for the ultimate sale, as Justin so clearly walked through with Ronco, if you think you're going to sell in a couple of years, now's the time to change those employment contracts. It's tough. It is really tough. The morale might be a little shot, but you find the opportunity, you change the employment contracts about the enforceability of termination provisions, and most of what we just talked about is no longer as big of an issue. So that's a key takeaway.
You're touching on something, I think, Alex, that kind of, obviously it's a sale, right? So the purchaser and the vendor want different things. No one wants to be liable for the employees, but you're describing a situation in which that very early due diligence and discussion can pay dividends, because what you can have is a substantially different terms situation that turns into a substantially similar terms situation if those terms are implemented by the vendor with enough runway that they're in effect, and then the purchaser can say, yeah, I'll give them the same terms if you make these the terms. And they've made those the terms, the purchaser takes them on, the vendor doesn't have to worry because there's a mitigation element, there's a continued quote unquote employment element. So that's really the best thing to do, and that
Yeah.
maybe can be the
early
highlight.
Due diligence minimizes the liability of the employee.
Yeah.
And I think no, just the other, I just wanted to raise, so, you know, Will and I, we've had a case where there was a sale of a business, and the key salesman came over, and so there was a substantial holdback in the transaction, and based on future profitability of the company. And then as soon as the employees came over, the new purchaser made substantial and unreasonable changes to the terms of employees from the vendor's perspective. And as a result, all of the salesmen quit and went to work for a competitor. And as a result, there was a large reduction in the holdback, and the vendor client said, well, we want to be paid that holdback because the only reason you've lost profitability was your own decision to constructively terminate all of the key salesmen. And so it's a very much a lose-lose situation, because the purchaser has lost all the profit, and the vendor has lost the holdback, and all because there wasn't any thought put into what would happen to the employees over the holdback period. So I think I saw a question pop up.
Hi, it's Jerry. Can you guys hear me?
Oh, yes.
Yes.
Hi, Jerry.
Okay, hi, how are you? Really well done, guys. This is a great summary of this whole subject. At the end of the day, what is the most common outcome? Like, we've done lots of transactions, and I would say from our own experience, most of the time, asset sale or share, the purchaser takes the employees and takes the liability. So you guys see a lot more transactions. What's your observation on the most common outcome?
Yeah, I'll jump in real quick, and then I'll let the other guys jump in. Yeah, Jerry, I often see that too, partly because often the vendor hasn't thought enough about in advance, and then the purchaser is going to do their due diligence, ideally at an early stage, and sort of hopefully knowing what they're getting into in terms of employment liability. Where the issues we're talking about crop up, though, is where halfway through due diligence, or the latter half of due diligence, they all of a sudden see, oh, you actually have 20 people with no valid employment terms, which we don't like. So then it becomes a whole indemnity issue. The purchaser might just say, okay, well, we're not taking these 3 or 4. Well, those 3 or 4, if they're 20-year employees, human rights considerations aside, could be a relatively substantial sum. So the larger the deal size, at least in my experience, this can fall a little bit by the wayside because vendor's so happy to get the value. So you're right, Jerry. It's usually the purchaser that I see is going to take on most of it, most of this liability, but it doesn't. We've also seen deals stop in their tracks, especially if the deal size is more 2 to 5 million. When the purchaser might not have completely understood employment law, they get their advice and say, "Wow, that's $1 million. That's
Right.
$1 million liability that we have overlap in our team, and we just don't need it." And that's a bit of a showstopper for that type of transaction.
Thank you.
I'll say that I usually encounter it. I obviously don't do M&As, but I usually encounter it from the other end. And so I usually see people who haven't been hired by the purchaser, who have a not a huge claim, but they have a claim for wrongful dismissal, which can be in the tens of thousands up to 6 figures. And when a vendor doesn't anticipate that and hasn't provided enough notice, that can be big for them. That can be even 1 or 2 of those claims, when combined with the headache of litigation, the legal costs, that can be a major stumbling block for them. It takes most of the benefit of the sale away in some ways and makes them want to stop it. So, but I agree. I think in most cases you'll see the purchaser taking on quite a bit of the liability just because they need the going concern. So, yeah.
Yeah, I guess you're also stressing the importance of thinking about selling the business well in advance of actually doing it.
Well, I had a situation just recently where someone gave great notice, 2 years notice or a 1.5 year notice to all their employees, and they said this is happening. And then the pandemic happened and the sale didn't go through, and they just didn't communicate about it. And then they wanted to do the sale in a couple of months, but of course there was a question of whether or not they'd lost that chance. So that was a good example for me of, if you do this well in advance, it gets rid of a lot of these questions and concerns, because it was the exact same situation, exact same employees, exact same business, but the timelines were changed, and the stress really came, you're right, from that lack of notice and due diligence and having the time to deal with it. So,
Right. Thank you.
Justin, I'm wondering, Carmelo has asked a question in the chat box, which you've answered. Do you want to share that with the group, just to elaborate a little bit more on that?
Yeah, Carmelo asked whether the new legislation that to make non-competition clauses in employment contracts unenforceable, he wants to know whether that would affect non-competition provisions in asset or share purchase and sale agreements. And my answer is, I think it's too early to tell right now. We'd have to obviously see what the legislation says. I've had some discussions with colleagues about like some of the draft wording I've seen, which seems very broad to me, and it might even affect the enforceability of non-solicitation provisions, which would be an unintended, I think, consequence. But I would think not. I would think that non-competes in a asset or share purchase sale will likely still be enforceable. It seems to me there's different considerations in play. I think there's going to be some overlap. Like if you are hiring the former owner as an employee for some period of time after the purchase and sale, there might be some different kind of considerations. But yeah, I think typical lawyer answer, it depends.
I think they've proposed some. I have to go back. I haven't looked at it since it came out, but I think they proposed some sort of exclusion, some kind of carve out for the asset and sale situation. But what that means is just insane. We'd have to wait for the language. So yeah, I second what you're saying.
I think it's just going to mirror ultimately what I've read. I think it's probably going to mirror the common law, which really is that non-competes were generally unenforceable vis-a-vis employees, but non-competes were enforced vis-a-vis former vendors. So I think that's the way it's going to be, frankly. And I think Justin's point's well taken. That there was a time where people would put non-competes into the share purchase agreement and a non-compete into the employment agreement if the guy kept on being employed. And I think probably the employment agreement isn't going to have a non-compete anymore.
I think we should introduce Leslie Diskin. I don't know if he was introduced. Mr. Diskin is the head of the employment law group at Brauti Thorning with Will and I. And we invited him to answer questions with us today. So if anybody wondering who Mr. Diskin is, thank you, Leslie, for your valuable insight.
Yeah, I think the purposes are going to mirror the way the common law has been. So
yeah. And Jerry, just to flesh out your comment about these considerations in the agreements, and I hope you're still there.
Yeah.
Okay, great. Yeah, because this is just building off what you raised. You could get into the weeds a little bit in a more practical setting and in the situation you're describing on the indemnity provisions in the asset transaction. So perhaps as a vendor, keep in mind the vendor might not be around very long post-sale, but the other guys could probably talk about this a little more knowledgeably too. But you could potentially be on the hook for termination costs that arise due to actions of the purchaser. They've taken on some liabilities and let's say they dismiss an employee shortly after. As a vendor, you want to make sure that's not going to be flowing back to you when you make the sale. So it would make good business sense to make that clear in the agreement.
Yeah, good point.
A real obvious one, and this one's less likely, is if the purchaser went bankrupt, everyone's going to look back at the vendor. That seems less likely. So I'm really talking about some unscrupulous conduct by the purchaser, and the employee doesn't care. They're just looking for a target. They'll also go back to the vendor. So that's an indemnity you can and probably should address.
I think another an issue, and we'll touch on it very briefly, but the human rights considerations. If you're hiring, 75% of the staff from the vendor, but you don't hire the woman who's on maternity leave at the time, right? Or you have people on short-term disability or long-term disability, you hire everyone except them, you're gonna be exposing yourself to a human rights claim. And so you need to talk about those kinds of liabilities and how you deal with them early on, right?
Yeah, or you don't hire everyone over 65. That's a slam. Yeah.
Does anyone have any further questions?
Maybe one general comment, which is just that for those employees that in an asset purchase that are hired, the purchaser's exposure is going to be reduced over time because effectively they're working out their previous notice periods in the first 6 months, 9 months, 12 months, so on of their new employment. So the exposure is slowly reduced over time, except for those employees that somehow are constructively or terminated probably in the first 12 months of a purchase. But after the 12 months of a purchase, there's a substantial reduction in collateral exposure, I think.
On the vendor.
Of the vendor. Yeah, exactly. I've seen them go all different ways in terms of assuming the common law exposure or trying not to assume it.
Yeah.
Interesting.
Yeah, and the other problem you have is the Employment Standards Act that's been mentioned, and I'm not really clear myself whether you can double recover if you're an employee. So if the vendor pays out severance, like termination pay and severance pay under the Act at the point of sale, can the employee, 3 years later, if they're terminated, claim that it's continuing employment and get a payment again?
Right.
For the same amount. That would seem
Yes.
to be counterintuitive, but
Yeah, it's not extremely clear. I think for severance, there, as you were hinting at, there is a specific provision to prevent that double dipping. But it's very tempting for that purchaser to say, well, why don't you just fire everybody and I get to start with a clean slate? And then pay them their ESA minimums. That's it. That's all you have to do. Well, I don't think
it might be that that's what you want to do, but the purchaser needs to be aware that it might not be a clean slate. You might still have some ESA exposure, and as long as you're, they have to be prepared to accept that risk.
That's exactly it. It's a move that doesn't necessarily accomplish what you think it is.
And something, just as another fun ESA question to think about, is that severance doesn't accrue in the same way as termination pay. So if you take on that liability and you find out that this person was employed for 10 years ago and then came back to the company, there's a basis to say that the severance is counted on that basis. Because it's the way it's phrased in the ESA, it may be that liability is much greater than we originally thought. So, because there can be a break in employment and it still calculates it. So,
what if your previous employer, under your previous employer, you're entitled to severance pay. Under your new employer, you're not under the Act. Then what?
Well, that's an excellent question. The vendor left that liability in, maybe you have a creative argument. That's what I was kind of getting at with the signing bonus, even if it's not strictly required, is there's a lot of things and what ifs that can come up, and making sure people are happy and just accepting terms of employment is the best way to go about it.
And what about the opposite situation where you pay out ESA minimums on the vendor pays out ESA minimums and is not obligated to pay severance, but then he starts working with the purchaser who is obligated to pay severance, and so there's not really double dipping if you get the full severance, right? So anyway, there's
Yeah, I mean, I've had experience with one employer. They bought a company, and they hired a fair amount of the employees, and I think they maintained their previous salaries for a period of time, and because the salaries were higher, and then everybody had to decide 6 months later, I think, or 12 months later, whether they were going to accept the new terms of employment, which kicked in after a period of time of employment with the purchaser. And the experience was that very few people opted out, actually.
Right. So they took a pay
the
cut
Ronco
after 6
pack,
months.
right?
Yeah. So basically everybody who stayed took a pay cut. Yeah, not insignificant pay cut.
Which, again, Jerry, goes back to what you're saying. So you're the vendor. I don't think you'll get away with saying you have to keep their employment terms static for 18 months, but you sure want that indemnity, saying if you alter their employment terms based on from what you hired them, then you are solely responsible for that liability. No one's going to be looking backwards at us.
Yeah. Oh, excellent point.
Are there any last questions? I want to be cognizant of time because we did book an hour and everyone has very busy schedules these days. So if there are any other questions, hands up or chat box or ask live.
No, just thanks a lot for the invite, Lisa. I enjoyed this.
Okay, great, Jerry. Thank you, everybody, for joining. Really appreciate your time, and a big thank you to Justin and William and Alex. They've put a lot of time and effort into this. It was really informative, and I hope everybody enjoyed, and enjoy the rest of your day. We look forward to chatting with you soon.
Bye-bye.
Thanks, Lisa. Thanks, everybody.